Welcome to the Legal Hour this afternoon. I'm Keith Spencer with the law firm of Bailey Galyen, and we are filming today from the Legal Cafe at 114 Main Street in beautiful downtown Fort Worth, just across from the courthouse. Today we're going to be talking about family law, and with me today is Mai Milton, and she is one of our family law attorneys extraordinaire. She offices in the Arlington office. And hopefully we can kind of discuss a few things that seem to baffle people about family law and what's going on in the world of family law, because one thing we can tell you for sure is it ain't like it looks on TV. Okay, it's not nearly as theatrical or anything like that. So let's say that you're having a family law issue, whether it's custody or adoption or divorce or whatever, okay? And you find yourself looking for representation, someone who can help you navigate the twists and turns of a family law dispute. Mai, what should people be thinking about when they're trying to choose a family law attorney? Because you can't swing a dead cat around the courthouse and not hit one. There's a whole bunch of folks, so how do you choose the one that's right for you?
You literally have to go with what feels right. When I have clients come into my office, I always tell them that selecting an attorney, whether it be me or someone else, should be a partnership, okay? It's not, this is the person that, so-and-so told me that I should get to represent me. You literally have to feel out your attorney. And you have to feel out your attorney because this person is being entrusted with some of the most intimate aspects of your life. If you're not comfortable with your attorney, they're not going to represent you well because you're not going to be comfortable enough to tell them all of the really finite details that you don't want to tell anyone, or that you forgot or you want to forget. So I always say make sure that whomever you're choosing, one, you've looked at their credentials, that you can start there. You can look at reviews and start there. But talk to them. And talk to them not just, okay, I have this problem. Get a feel for their personality. Some attorneys are very, very type A.
That's diplomatic speak.
Some are
very wound up a little tight about themselves.
Correct. Very, very stoic. Some are not. And if your personality is where you have to be in control of everything, it's not going to fit you to have an attorney that does not complement your personality style. So, I would tell potential clients all the time, I've been doing this for a while. I am not wound tight. My clients call me Attorney Mai. They call me Mai. They call me Attorney Milton. Just call me.
Okay. But, So you're looking for an attorney, and you're talking to Mai as a candidate to be your attorney. Okay. If you're there looking for someone who's going to tell you what you want to hear, then my guess is you're going to be kind of like me. You're going to want to disappoint them as early in the interview as possible.
Correct.
Because there are folks who come in saying, I'm shopping to the attorney who's going to give me the answers I want to hear.
Well, I could definitely tell you what you want to hear, but that doesn't mean it's going to be so if we take it into court. I believe in full disclosure. So you don't want an attorney that's just going to tell you what you want to hear, because what you want to hear may not be in conformity with the law.
It's not going to be much help.
It's not going to, and then you're just, what do they say, throwing good money after bad?
That's right.
So,
how about this? As an attorney, client comes into you for help.
Okay.
Which clients do you look at and listen to and say, oh no, this ain't going to work?
Clients that have unrealistic expectations.
Bingo.
If I am speaking with a potential client, I'm interviewing them just as much as they're interviewing me. And I've been doing this so long that typically I can hear if a client has unrealistic expectations. And if you can't mitigate that or figure it out and kind of get them to a level where it's realistic, then nothing you do will be on par for that client. That client will never be satisfied with you. That client is going to be disgruntled. That client will not be happy overall. You'll go into court and you'll say, well, we told you, or I told you that this wasn't happening.
They won't be a very good witness either.
Yeah.
Okay.
So, you have to have a realistic expectation. And even if you go into your potential attorney's office with these thoughts that you think can occur because you've watched, these legal TV shows that don't operate the way it operates in real life, your attorney should be able to tell you that's not going to happen. That's not going to happen. I'm sorry. We get you as close as possible to what you want within the confines of the law. Sometimes that's what they want. Sometimes it's not.
And as a client, you really need to share with your attorney what are the most important things to you. I'll ask my clients, what are the 3 things that are most important to you? Because nobody's going to walk in and hit a home run on every pitch. And your attorney needs to have some way of prioritizing what is truly important to you, because there's going to be some give and take, and the courts are not prone to enjoying the fact that a case might generate a winner and a loser, okay? Because families are important, the welfare of the kids is under consideration, and so no one's going to go in and hit a home run on every pitch. So you really need to let your client, your attorney know what's the most important things to you, so that you can develop a realistic approach and show the court why on these particular issues your point of view is so important. Unfortunately, today, there is such a wealth of information available on social media and from your buddies at the bowling alley and your co-workers and the other folks at the barber shop. It's well-intended advice, but it's generally wrong.
Correct.
The practice of law is kind of interesting. There's a general rule, and then 47 exceptions to that general rule, okay? And the problem that folks have is that they have an oversimplified understanding of what the general rule is, and they put all their eggs in that basket, and only to find out, wait a minute, there are exceptions to that rule. So the other thing I'd tell you is, don't be shy about interviewing more than one attorney. It will not hurt our feelings if you're asking around and looking to see, who might be the best fit for you, okay? But you got to do a couple of things. If you want to have a chance and you want to have the benefit that having counsel will afford you, you have to tell your attorney the truth. Because when we find out stuff for the first time on the witness stand, it's a little late for us to do damage control.
That's
all right?
Yeah, I have come to Jesus moments.
Absolutely. And you've got to trust your attorneys enough to tell them the truth. And then you've got to pool your resources and put your heads together to come up with a game plan to make your most persuasive case. So we're preparing for, let's say it's a divorce, all right? One of the things that's going to happen in a divorce is we're going to be dividing up property.
Correct.
Okay? And one of the aspects of that is a thing called discovery. Okay? And it could be, I'll show you yours if you show me mine, okay? We have to produce bank records to each other, and deeds, and income statements, and retirement account statements, because we don't allow people to ambush you at court anymore. Okay, you ask a question, say, show me how much money's in that retirement account. If they don't show you, then bad things happen to them. If you don't agree to show them properly requested documents, bad things happen to you. Like you can't put on your case. And this is a common experience we have where we'll forward the discovery request to our client and we get some real pushback about that's none of his business.
Yes, I get that a lot. It's not relevant. He's not entitled to this information, or she's not entitled to this information. Yes, they are. I've had many conversations just on that road. When you are preparing for your divorce, if you know in advance, if you're not the one that is getting filed on, and it's not a shock, typically people know it's not working out.
Right.
You need to start getting your affairs in order, like people say. You need to start pulling your financials, put it in order. You need to pull any documentation that you may have. Pull the deeds to your home, your mortgages, your bank account statements, your credit card statements, your children's educational records, if your kids are at play. The best clients for me are the ones that come in and they say, "Here, attorney."
And a notebook.
Yes, and
it's indexed.
Yes. Now, I'm not super wound tight, but I appreciate everything being in order. And that's going to help you because I tell clients all the time, you can give me a bundle of mess and I'm going to sort through it, but in me sorting through it, you're getting billed for it. So let's be a good steward of your funds.
You can pay her $400 an hour to go through your checkbook register, or you could organize it for her and save yourself a bunch of money, okay, and a whole bunch of time. All right. A lot of times, someone will come in and say, "Well, I don't know. They pay all the bills, or I don't know what our income taxes look like, or things like that." A lot of times, I've advised people, well, let's not pick the fight yet. Let's not go file this. Why don't you go home and over the weekend, why don't you make some copies of your income tax return, your bank statement, that sort of thing, so that we know what we're talking about before we jump into it, and before, God forbid, all those records end up in the barbecue pit on fire, from the time you served them, right?
Right.
So preparing for a divorce can include, gathering the necessary documents. The other thing that it might entail is I ask my clients when they come in to see me on a real altering case like a divorce, what is your 5-year plan? Well, I haven't worked outside the home in the last 12 years. Have you thought about what you might do after the divorce? Because you may need to start making some plans. If you need to go get your license re-upped, if you were a realtor or a nurse, or do you have your teaching certificate? Are you prepared to be able to start looking for a job? There's a lot of things that you can do to make your life a lot easier.
And also, by the same token, preparing for a divorce, no one ever talks about preparing yourself mentally for a divorce. A lot of times people go into a divorce thinking that it's going to proceed one way, and it does not. And it throws them mentally for a loop. The practice of family law, the practice of representing people in divorces, it is bringing together what your head is thinking and what your heart is thinking. And so in preparing for your divorce, if you've not been slammed by it or surprised by it, even if you have to start rationalizing and understanding your emotions and your feelings. That might include talking to a therapist, seeking counseling, shoring up your mental resolves, because not every divorce is friendly or amicable. We see some of the nastiest aspects of people in divorces. So you shore up your resolves. Make sure that you have the mental fortitude. Of course, as attorneys, we're there to be your biggest, champions and to help you, but you also have to do the work yourself to shore up yourself so that it does not break you. Because I've seen that happen with people before where the divorce mentally took a toll on that person and broke that person.
You also have to remember that there are only a few things the court can do, all right? The court cannot make life fair, and the court cannot redress the fact that someone was unkind to you. And going to court is not, I'm gonna file divorce and that'll make him go to rehab once and for all. I'll change his behavior with the threat of these divorce papers, okay? That's gonna scare him into good behavior.
For a minute, maybe. Maybe.
Okay.
For a minute.
So just remember what the court can and cannot do, all right? It is not a tool for marital therapy.
Right.
It is not a tool to make someone behave better or be more understanding or sympathetic. It's a serious thing, and the court can only do what they can do. Now let's talk about something that I think is very interesting. More than 95% of the cases that get filed in family court settle
Correct.
before they get to final trial. And I think there's really good reasons for that, like the two smartest people in the room, the husband and wife, are making the decisions, okay? Because let's face it, they know their kids, they know their money, they know their house. They know that a whole lot better than that judge is ever going to be able to ferret out in a trial. And secondly, the judge has handcuffs on. The judge has guidelines that they have to follow in developing child visitation schedules and child support schedules and dividing property and retirement accounts and what do we do with the house. When we prepare for trial, before we get to final trial, in almost every case, I would bet, you can tell your clients within 50 cents what the judge has to do.
Correct.
Faced with these facts.
Correct.
Okay? And when you tell your clients, this is what the judge will be required to do when we finally get to trial in 8 months and after a whole lot more money, how often do they say, well, that's terrible, we can come up with something better than that?
I have had clients do that before, and then I've had clients that just rejected that information, unfortunately. The court is bound by the Texas Family Code. And so if you and your ex-spouse, soon-to-be ex-spouse, come up with a workable plan for you and your household, then wonderful. The best way to make sure that that is locked tight is mediation.
Yes.
I love mediations, and I'll tell you why I love mediations, Keith.
Okay.
I love mediations because mediations take the control out of someone who does not know anything about your life, that may see you for maybe 20 minutes to a couple of hours. They do not know how you function and how you interact, and it puts the power back in your hands, right? And so if you can come to a resolution during a mediation and you leave the mediation with what is known as an MSA, mediated settlement agreement, it's locked tight. The judge cannot go outside of the parameters of the MSA. So I love mediations
and
for that reason.
the other side can't change their mind
Correct.
tomorrow either.
Correct. It is non-revocable. Once you have it, it's done. I did a mediation recently, and we knew how it would play out before this judge, and what the other side was asking for was unrealistic, and we're going to take it to trial. Took it to trial, tried the case. The exact thing that we said would happen occurred, and maybe it took that for that other party to see that what we were saying was in fact true, but...
Well, when we start a mediation, the mediator will go back and forth between the two rooms. You're not sitting in the same room poking each other with a fork, okay? The mediator goes back and forth like Kissinger at détente, and to see if they can broker a deal between the two of you. And it's not uncommon that one side will say, I want the very best day I could ever have in court. I want everything. It looks like a Christmas list,
Yeah.
okay? We're just gonna win everything, you're gonna lose everything. Well, that's not where the case settles at, okay? And sometimes, people can't get past their nose, and they're gonna insist on going to trial. But the other thing about mediation is it will save you a small fortune,
Correct.
okay? There's a few things that people perhaps misunderstand. Someone walks into your office and says, we've got 3 kids, I want sole custody. What are you going to tell them?
Okay, first and foremost, lay people get the terminology confused, okay? Everyone says, I want sole custody, or I want joint custody. Okay, for purposes of the law, there is conservatorship, joint managing conservatorship, sole conservatorship. That's dealing with the rights and the duties to make decisions for your kids.
Mm-hmm.
Possession and access is something entirely different, okay? So even if you said, I want sole custody, what does that look like? Because the other parent still has a right to possession and access, barring some other mitigating factors, where he could not or she could not see the children.
But they're fairly rare.
Correct. It's really hard to get sole managing unless you have
you're in prison.
Or you're on drugs.
Yeah.
Child neglect, abuse that's documented.
Mm-hmm.
Family violence with the kids. It's really hard to get sole managing conservatorship. But you can get joint managing conservatorship. That's the default.
Mm-hmm.
And that's just talking to the rights and duties, who gets to make what decisions as to the medical, the psychological, who gets to make educational decisions, who gets to enroll the kids in school,
Mm-hmm.
who can hold the passport or apply for a passport. That's dealing with conservatorship when people say custody. I think that when people are talking about custody, they're talking about the possession schedule.
Texas doesn't use the word custody.
Right.
Okay, and so when you say custody, you're using a word that only appears once in the Texas Family Code, and that has to do with something other than visitation.
Correct.
Okay. The other thing that folks have to remember is when we say joint custody and sole custody and that kind of thing, we're not necessarily talking about 50-50.
Right.
Okay, having joint managing conservatorship means y'all are going to talk sometimes about what's in the best interest of the kiddos. Y'all may have to agree to some decisions.
Right.
There may be some decisions that are going to say, we're going to let mom make these decisions and dad make these decisions. We'll probably have a geographic restriction that says, okay, you cannot take the kids and move to Nebraska to make it harder for the other parent to get to see the babies.
Right.
Those are some things that are pretty well given, and we understand how that's going to work. Another line I hear frequently is, that woman's going to put me on child support.
Child support is for the benefit of the child. And if I can just state this unequivocally, it does not matter if the person receiving the child support uses the child support for their rent, for their lights, for their car note, for their insurance, because if it is benefiting the child, it is benefiting the child. Little Johnny or little Susie lived in a house with mom. Mom has to pay $600 a month rent. Back in 1992, maybe not anymore.
But they need electricity, they need water.
They need gas, they need food. So it is not so much when you pay child support. One, it's based upon guidelines. Texas establishes guidelines. Depending on how many kids you have, it goes off of your income as the payer, right? Her income or his income, whoever has the kids, their income is not calculated at all. Just so you know, we're not Florida. Florida does that.
Yeah.
We don't do that.
The judge wants to make sure that the kids have a certain reasonable amount of support, and they're not going to be eating caviar at one house and bologna at the other. Okay? So saying, well, I feed them dinner when I'm visiting. Well, that good. You're supposed to do that,
Right.
okay? But there's a whole lot of expenses that kids have, and the court is trying to be as fair as they can, but they also have guidelines. And friends and neighbors, if you think what is being paid in child support comes even close to what it costs to feed, clothe, and shelter your child, you're mistaken, okay? Because for one child, that's 20% of your income,
Right.
okay? And so the court, there are strange exceptions, rare exceptions where the court is allowed to deviate from those guidelines for good reasons, but they are rare, okay?
Mm-hmm.
And so you should walk into a case knowing what your potential child support exposure is. And if a lawyer says, oh, don't you worry about that, I'll make sure there ain't no child support in this case, then run from that attorney.
For the hills.
Okay, because they are not shooting straight with you, and they're not telling you realistically what's going to happen in court. Okay?
Okay. A lot of judges, and you'll agree with me,
Sure.
a lot of judges won't even sign off on a decree if it's involving children and there's nothing that's with respect to child support in that decree.
That's true.
Judges will reject the decree, the final decree, and say, no, where's the child support at?
I've had folks come in and say, Mom and I made an agreement, there ain't going to be no child support. We put it on writing, it's been notarized, it's like sprinkling legal pixie dust on it, and we've got us a contract. Well, husbands and wives are not allowed to contract between each other,
Right.
for starters, and secondly, it's against the public policy of Texas for parents to enter into any kind of contract that could result in the child not having food, clothing, and shelter.
Correct.
So you can't do that, all right? Ma'am, if someone is contemplating coming to see a lawyer about an issue they're having in family law, how can they get in touch with you, and what would you want them to think about before they took that step?
They can get in contact with me by going to our Bailey Galyen website, definitely. I'm at the Arlington branch of Bailey Galyen. We also have a phone number where they can reach us at. All of this information, I could give it to them and spew it right now, but
Go ahead.
just go to the website. If
There you go.
Go to the website. When you go to our Bailey Galyen website, you're going to see my vignette. You'll see the vignette for all attorneys. You can get a feel for who I am. If you are interested in retaining with my office, I am one of many offices with Bailey Galyen. You can call, you can click, and they can get a same-day consultation a lot of times.
And ma'am, do you charge anything for your first interview?
The first consultation is 100% free. 100% free.
So they got nothing to lose coming to ask you a question.
Correct.
Or several questions. All right. At Bailey Galyen, we do have free first interviews, sometimes second interviews. Okay. You really don't want to rely on Google or your coworkers to provide you with critical legal advice that's going to impact the welfare of your children, your family, your livelihood,
Correct.
that sort of thing. And Google's a wonderful thing, but it's kind of like deciding I'm going to start the appendectomy in my garage and I'll just call a doctor if it gets out of hand. Bad things can happen, and since it's free to talk to a real lawyer, it sounds like a pretty smart thing to do.
Right. And we have, Bailey Galyen has over 40 years of experience representing members of the DFW and greater DFW area. Not just in family law. We want you to call for our family law, but we also have attorneys in other areas of law as well. So if you have a legal issue, a legal concern, think of us, because most of our consultations are 100% no cost for that first consultation. You can get some legal advice, or at least a place to start, you know? A place to start. And a lot of people don't know even where to start. So
Correct.
Make that call. It might just steer them in the right direction.
That'll wrap us up for today from the Legal Hour with Bailey Galyen. Please give us a call if you need help.
Bye.